10, 9, 8, 7, 6, 5, 4, 3, 2, 1.
Ladies and gentlemen, it's showtime!
Hey, howdy, and hello, ladies and gentlemen. Welcome to Talk IRL. I am Gregory, otherwise known as the Redneck, and tonight's talk is the California law, SB 107, transgender protection law that is right now sitting on Gavin Newsom's desk, waiting for him to sign it. And I'll tell you, if you're a parent in the United States of America right now, and any other state other than California, and maybe even in the state of California, this law is going to absolutely raise the hair on the back of your neck. And if not, then this probably isn't the show for you. So let's talk about what this thing does. So first thing it does is it turns California into a trans sanctuary state. You know, look, I don't condone any sort of activity on a trans person that would be considered violence. But as you'll find out momentarily in this law, what constitutes violence today would not constitute violence, say, when I was a child. So we're going to get into that as part of this law. So the other thing it does is it allows for the transport of a child to California by anyone. Yep, that's right. No, it's not a mistake. It's not a misinterpretation. A child to be transported by anyone to the state of California from any other state in the union. That's right, without legal repercussions. And it doesn't even have to be their child. They don't even have to be the legal guardian of said child. They can be anyone who transports that child to the state of California. I know you're shaking your head. You don't believe it. We're going to get into it. Any child that enters the state of California and identifies themselves as someone who is seeking gender transformation will immediately and instantly become a ward of the state. So if that child shows up without their parent, they immediately and instantly become a ward of the state, and those parents' rights are immediately and instantly stripped no matter what state they live in. So get ready for that one. Gender-affirming medical procedures of a minor child without parental consent. So yes, that's right. Your 7-year-old son can go to California and have his penis removed without your permission. Yep, that's right. And there are no age limits. This law does not set, and nor do any other laws pertaining to this, set any age limits. Your 4-year-old child can go to California and get hormones and gender-affirming surgeries. That's right, gender-affirming surgeries they can get all without your permission. You know why? Because once they get across the state line, they become a ward of the state. And the state says that they can have any gender-affirming surgeries, procedures, processes, and mental coaching that they desire based solely on their desire for it and nothing about what you want as a parent. All right, ladies and gentlemen, let's break this thing down. SB 107, Section 1, Paragraph 1. So the first paragraph affirms that interstate extradition is normally upheld. And here's what the actual law says. It says, the United States Constitution generally requires a state to give full faith and credit for the public acts, records, and judicial proceedings of every other state. Existing law authorities, upon the demand made by another state, the extradition of a person charged with committing an act in the requesting state that results in a crime in the demanding state as specified. So, yeah. So in plain English, that essentially means that the portion of this law states that a law broken in another state in which the other state is requesting that the person be arrested in the state of California, that they would normally and customarily be returned to the requesting state. This is setting the stage for what's to come, so there's no confusion about the fact that California, under normal circumstances, will enforce laws from other states as part of their normal and customary extradition laws. Section 1, paragraph 1 also affirms that child support will be demanded by the state. And it reads as follows. Existing law sets forth procedures in which a person may enforce judgment for the payment of money and child custody orders issued by the court of a state other than California. Existing law authorizes a California court or attorney to issue a subpoena if foreign subpoena has been sought in this state. So in plain English, what this means is essentially the portion of the law that says if someone brings a child to California, that the person may demand child support while that child remains in California. My suspicion is that this also applies to an entity requesting child support from the parent. And there are other lines in this act, in this law, that do suggest that even further. And I'm thinking that this even applies if a runaway child is placed in a foster care facility, that the state can then force the parent of the child to pay child support to the state. I think that this is incredible. So Grayson, what do you think about this thing where California affirms that child support will be demanded if your child crosses the state line?
Wow, let the insanity begin, right?
Right.
This is absolutely ridiculous. Your child goes to California, you've done absolutely nothing wrong. You have not abused your child. You have not done anything to this child to harm it. And they're going to say that you need to pay child support, not only to either could be to the state itself. That's crazy. Child support to a person that may have kidnapped your child and took it over across the state lines.
Yep. Aunt Susie takes your son across state line.
Gosh, that's just I don't know. That's mind-boggling in itself. I don't see any logical person could even put a bill like this in front of anybody and that people would actually vote for it. This is crazy. You're losing the rights to your child for no other than, I think I might want to be a female if you're a male. I think I might want to be a male if you're female. That's crazy.
At any age. That's the scary part.
Child.
Yeah, a child.
I consider a child being someone who's 14, 15 or under. That's how I look at a child. That's the age of innocence where you're to protect your child. And you're actually taking that authority away from a parent to protect their child from something that could be harmful to them, they could regret.
Right.
And you're paying for it. You're paying for the child.
Absolutely.
That's ridiculous. Like I said, let the insanity begin. Thank God I don't live in California.
Yeah. Amen, brother. SB 107, Section 1 also affirms that it is illegal for a health provider to give information. And here's what the law reads. Existing law generally prohibits a provider of healthcare, a healthcare service plan, or a contractor from disclosing medical information regarding a patient, enrollee, or subscriber without first obtaining an authorization unless a specified exemption applies, including that the disclosure is in response to a subpoena. So in plain English, guys, this means that the section reaffirms that a healthcare provider of any kind is prohibited from revealing gender-affirming medical procedures, medicines, or mental health assessments from anyone. This section also affirms that the state will not respond to subpoenas for information from other states. In other words, if you're a parent from another state or even from California itself, healthcare providers may not release any information regarding healthcare issues, even if that person is a minor and you are their legal guardian or parent. But as you'll see later on, even that becomes a matter of contention if your child crosses the state line of California and requests asylum based on gender. That's another thing, and we'll get into that here very shortly. All right, ladies and gentlemen, let's talk a little bit about SB 107, Section 1, Paragraph 2. And essentially, there are three components to this paragraph. Number one states that children are not exempted from the law. Warrants from other states will not be enforced, and California law enforcement agencies cannot enforce extradition. And so on the first part of this, kind of the first sentence of this, the law reads as follows. This bill would prohibit a provider of health care, a health care service plan, or a contractor from releasing medical information related to a person or entity, allowing a child to receive gender-affirming health care or gender-affirming mental health care. So kind of in plain English, this means, again, this states that anyone in the health arena cannot release medical information, specifically if that child is seeking gender-affirming health care, including sex change operations, hormone drugs, and mental health evaluations. I think this is absolutely nuts. Where do you land on this, Grayson?
Crazy town. Absolutely crazy town. It's just that this is just it's ridiculous. This whole law is crazy.
Yeah, I couldn't agree more. I mean, the whole thing is bonkers, but the notion that a children is not exempt, that a child can go in and have their penis removed, and they're not exempted from, and no one can talk about it, no one can tell the parents about it. That's insanity.
Yeah, the parents. I mean, the children. We're talking about children here, not adults, not teenagers. We're talking about 8-9-year-olds that can do this if they so please, and you can't tell the parents can't know anything about it at all. Nothing.
Right.
Nothing. No records can be released. Right. That's ridiculous. Again, I'm so glad I don't live in the state of California.
All right, so next in this little paragraph here, it says that warrants from other states will not be enforced. And it reads as follows. Foreign subpoena based on another state's law that authorizes a person to bring a civil or criminal action against a person or entity that allows a child to receive gender-affirming health care or gender-affirming mental health care will not be enforced. And so, in plain English, in other words, if someone takes your kid to California to receive gender-affirming surgery and your state has laws against such activities and issues a warrant, California will not issue a warrant for that person's extradition or prosecution in the state in which the laws were broken. So in other words, if you live in Texas and somebody takes your son to California, there's not any kind of law or warrants that will be enforced or executed in the state of California.
That boggles the mind there. I don't see how one law in one state can be greater than many laws of other states.
Agreed.
I mean, we're putting the law ahead of kidnapping, all kinds of different things. This opens so many Pandora's box on so many different things.
Wide open.
It's crazy. The sex trafficking in California is going to be a huge problem if it already isn't.
I agree.
There's going to be so many different things that are going to come out of this that the people of California are going to be happy about.
They're the ones that voted these crazy people in office. So the next piece of this says that California law enforcement agencies cannot enforce extradition. And the law reads as this. The bill additionally would prohibit law enforcement agencies from knowingly making or participating in the arrest or extradition of an individual pursuant to an out-of-state arrest warrant based on another state's law against providing, receiving, or allowing a child to receive gender-affirming health care or gender-affirming mental health care in this state of California as specified. Now, so in plain English, simply put, this means that this bill would prohibit any California-based law enforcement agency from arresting or extraditing anyone who had a warrant pertaining to actions involved with providing a child with gender-confirming operations. Now, my concern here is that it's very likely to extend to laws regarding the transport of a minor. So, I wonder how far this extends. If Uncle Joe takes niece Nancy to California to become nephew Nicholas, and he wasn't even the legal guardian of niece Nancy, will he not be arrested or extradited?
Obviously, from what they're saying, they're not gonna enforce that, and that's off the rails. You're telling law enforcement not to recognize laws they've been enforcing for so many years just because of this one law now.
Right. And, another question that I have is, what about a child who's, say, 13 years old, and they meet someone on the internet and they decide to exploit the law? Boyfriend Joe takes girlfriend Janie to California, where Janie claims that she wants to become Jimmy. California law would protect boyfriend Joe for taking Janie away from her parents as long as she claims to be interested in transitioning.
Exactly. Now this opens up what? This opens up the sex trade, the sex, all this stuff. It opens
100%.
up everything.
Yep.
It just, hey, I'm taking this child over here. They're gonna convince this 30-year-old man's gonna convince this 10-year-old boy that he wants to be a girl.
Yep.
And then he's gonna take him over to California, and it's gonna be right into the thick of it. You're gonna be on the streets, doing tricks, and just being used and abused. And then they're gonna say, well, there's nothing you can do because he went in one day and asked for some gender pills,
right,
to help him become a female. That's ridiculous.
And now the law has been exploited.
Extremely scary.
Yep, I agree. SB 107 Section 2, Paragraph 1 really introduces some really interesting things. And basically it says that your child becomes a ward of the state and that California can decline suits from other states. So again, they're preventing people from being able to bring suit against anyone who brings a child over the state line into the state of Texas. And so here's what it reads.
California.
Golly, yeah, in the state of California. Woo! Thank God I live in Texas. So here's what the law says. It says, existing law known as the Uniform Child Custody Jurisdiction and Enforcement Act provides the state exclusive jurisdictional basis for making an initial child custody determination and permits a California court to assume temporary emergency jurisdiction in specified circumstances. Existing law permits a court to decline to exercise its jurisdiction if it determines that it is inconvenient forum and in a court other than the state is more appropriate forum. So in plain English, this means that California has the exclusive right, meaning it does not take into account legal guardianship of parents, to decide with whom a child may live as an emergency status. Gender affirmation is considered by law to be a mental health emergency, thereby clearing the way for the law to find itself firmly in the realm of emergency custody. So, Grayson, your son could be taken to the state of California and would immediately become a ward of the state based on the fact that they're requesting gender affirmation, which is a mental health emergency, and boom, your rights as a parent are stripped from your child and they become a ward of the state.
Yeah, the wording here is temporary ward or temporary custody going to the state. I wonder how long temporary.
No, it's a temporary emergency jurisdiction. That's all it takes, though, is temporary.
Yeah. So what?
And there are other things in this law. As we move on through this law, there are other things in it that make it more permanent.
Yeah, it'd be that. Again, my son's 8. He can't even decide whether he likes Pokemon more than he likes Sonic the Hedgehog. So right. He really can't decide whether he wants to be a male or female. I mean, it's obvious that his brain function isn't capable of that, and that's what makes this crazy. That California is creating something's going to be a crisis one day.
I couldn't agree more.
It's going to be a crisis. We're going to be in the fight of our lives to protect our children and to keep our rights as parents.
Yeah, I couldn't agree more.
Fight.
So speaking of which, keeping your rights as a parent, California can determine to decline suits from other states. And the law reads as this: existing law permits a court to decline to exercise its jurisdiction if it determines that it is an inconvenient forum and a court in another state that is a more appropriate forum. So in other words, in plain English, California can decide whether or not any court proceedings happening in other states should be entertained. In other words, if you file a suit in Texas, California will not have to even allow your child to return for the purposes of the hearing, nor will the child be prevented from any ongoing transitional treatments, even though you may have filed legal charges in your state you reside in. So you file charges. California keeps right on giving them transformation surgeries, pills, mental health guidance for their gender affirmation, road that they're on.
Yeah, so California pretty much gets to abduct your child and do as they wish to it.
That's pretty much it, yeah. Yeah, they don't have to respond to any outside influence whatsoever, and they will actively reject lawsuits that come from other states. And again, I honestly don't know how one state's laws can override another state's laws, given where that person resides, is in that state.
And it's more consistent with the other 49 states than the one here that we're talking about in California.
I agree wholeheartedly. I consider it like the driver's license. When you get a driver's license in one state, it's valid in all 50 states.
Exactly.
And, this is one of those kinds of laws that I don't see how you can just overrun another state's laws, all 50 of them for that matter.
Especially when it comes to children. It comes to children. I mean, it's just this is taking advantage of the weak mind of a child, of the not weak mind, I'd say underdeveloped mind of a child.
Absolutely, 100%. Yeah.
And it's taking advantage of this, and it's allowing criminals to do things to our children that shouldn't be allowed to be done.
Agreed. All right, SB 107, Section 2, Paragraph 2. So basically in this paragraph, it says that your state says that your child was taken inappropriately. Doesn't matter. California doesn't care. And then it said that basically it says that your child can be taken by anyone to California. A neighbor, an aunt, an uncle, a friend, a stranger. Anyone can take your child to California. So let's talk a little bit about it says that your state was taken inappropriately, but California says no. This is what the law says. Existing law permits a California court to decline to exercise its jurisdiction if the petitioner has wrongfully taken the child from another state or engaged in similar reprehensible conduct, except as specified. Now, in plain English, that means that if your child was taken from a state in which it was illegal for that person to take the child, and you file a legal lawsuit against that person, California can decline to exercise any legal force to return that child to its originating state, i.e. you.
So they're stating that domestic violence or violence is not allowing your child to have a gender affirmation surgery or to be a male or female opposite of what they were born. Is that to say that that's child abuse?
Well, I mean, here it just says that it's, that they can, if someone files suit, that they don't have to do anything and they don't have to return the child to back to the parent.
And the reasoning behind it is because of that's absolutely nuts.
Yeah. Okay, and the next section says your child can be taken by anyone to California. Here's what the actual law says. It says that existing law prohibits a court from considering the taking or retention of a child from a person who has legal custody of the child if there is evidence that taking or retaining the child was a result of domestic violence. Now, on the surface, in plain English, under the existing law, if a different law from this one, a child was taken from a legal guardian or parent on the basis that someone was applying violence against that child, that the person who took the child would not be charged with a crime. On the surface, it makes perfect sense. If you see a child being beaten by a parent or somebody, and you take that child away and whisk them off to a police station, that is not kidnapping. Okay, you cannot be charged with kidnapping for doing that. And again, that makes all the sense in the world. You don't want to be restricted from helping a child who's being beaten. here's the rub. Once you couple that with a new law which says that misgendering a person is an act of violence and punishable by felony in over 4 states, and one of those being California, guess what? If you misgender your child, you've now created a violence against that child, and now someone can step in and take that child, and they will not be convicted of kidnapping. Now, what I don't know is, I mean, if that happens in Texas, and they take them in their car and they drive them all the way to California, what happens? You know?
Well, it seems to me that California takes a man and and allows them to get what they want when it comes to the operations and all that, and the pills for changing your gender.
Yep. Agreed. All right, ladies and gentlemen, let's talk about SB 107, Section 2, Paragraph 3. And essentially this paragraph says, if your state says no, California says F you, stay in California and continue medical procedures, even if you have an injunction. Courts in California can override your state's court. He who changes first wins, and everything in this law is severable. So let's get to the first part of this. If your state says no, California says F you. Here's what the law reads. It says the bill would prohibit the enforcement or an order based on another state's law authorizing a child to be removed from their parent or guardian based on that parent or guardian allowing their child to receive gender-affirming health care or gender-affirming mental health care. In plain English, if your state issues a warrant because it's illegal for someone to remove your child from custody and take them to California for the purposes of gender-affirming treatment, you're out of luck. California will do nothing about your case arising out of this concern.
Yeah, it's like you get the big moon, drop it down in the moon, and California saying, yeah, forget you.
Oh, yeah, exactly. Here's the finger, buddy.
You can go to
hell.
Yeah. Yeah.
Hell in a handbasket, which is where California's going, apparently. So the next part of this says that a child can stay in California to continue medical procedures. And the law reads as this. The bill would prohibit a court from finding that it is an inconvenient forum where the law or policy of another state that may take jurisdiction limits the ability of a parent to obtain gender-affirming health care or gender-affirming mental health care as defined, and the provision of such care is at issue with the case before the court. So, in plain English, if you file a lawsuit in your state, and that state is somewhere other than California, or maybe even in California, against customary tradition, the state of California will ignore the case and will not allow the child to return to the state in which the case was filed. This is actually against normal procedure. This case will then be ignored by California, and the child's treatments will not be impacted, even if you have a legal injunction from your state requiring the child not receive any more treatments until the court case is decided in a court of law. So even with an injunction, they're not stopping.
Yep, again, this whole bill is just trash. It's terrible. You're right, as a parent is so stripped when it comes to this new California law.
Like I said before, if the hair on the back of your neck's not stood up a few times, then I don't know what to tell you. Maybe you voted for this law, or maybe you voted for some of the people that would enact a law like this. I think it's absolute, positively lunacy. But let's continue on and dive even deeper into this pile of manure. So in this section, it also says that courts in California can override your state's court. I find this very interesting. And it's a real simple statement, but man, the implications here are huge. So it says, the bill would authorize a court to take temporary jurisdiction because a child has been unable to obtain gender-affirming health care. Man, that's a very simple sentence, but boy howdy, let's dig into what this means kind of in plain English. So basically it says if your child wants a gender change and you say no, the state of California may reach into your state and take jurisdiction. Essentially, what this means is that a child could literally pick up the phone and call the state of California, make the statement that they want to go through gender affirmation, and California law would take effect and override your legal rights in your state. The child would then be forcibly removed from you in your state in accordance with California law and placed into California. And we all know by now what happens when they get placed in California. They become a ward of the state, and you start paying child support.
They basically just came into your backyard, took your child.
That's it. All because your child made a phone call and says, I'm a girl, I want to be a boy.
Your child thought that that's what they wanted.
Yep.
For that day.
All right, so the next thing is, we call it he who changes wins. Here's what the law reads. It says, the bill would additionally prohibit a court from considering the taking or retention of a child from a person who has legal custody of the child if the taking or retention was for the purposes of obtaining gender-affirming health care or mental health care. So in layman's terms, it means basically if a parent absconds to California with their child for the purposes of gender affirmation and the other parent says no, California says you can't have them back. You can't stop the change, and will ignore any court that attempts to get the child back on behalf of the parent. So, if one of the parents decides that they're going to go and turn Jimmy into Janie, guess what? You can't stop them.
Yeah, that's ridiculous. One parent making that decision over another is, I don't know. California's gone crazy. They're off the rails.
Well, clearly, I think many times Grayson and I both have been leveled to pure speechlessness, which is unusual for us because, we have a YouTube thing going on, so we have a lot to say. But so for both of us to be reduced to complete and utter babbling speechlessness, that's saying something.
Saying a lot, because this whole thing here is just, when you try to comprehend it all and understand what the effects are going to be of this, it's crazy. You're just dumbfounded.
The ramifications of this law are far-reaching and will be very, very far-reaching. I can see. I can't even imagine. And we're going to discuss some of the things that I think are going to take place at the end of this thing. But so let's go on to the next thing. And basically, all of this whole bill is severable. And so the law says this bill would be severable and declare its provisions to be separable. In plain English, severable means that any part of this law can be enforced separate from any of the other parts of the law. Each part is independently enforceable and severable. So, basically what that says is if one part of the law doesn't apply, it doesn't mean that the whole law doesn't apply. It just means that one piece of the law doesn't apply. So, they can pick and choose what they want to enforce out of this law.
Yep. It's like a
mix and match law.
It's like a box of Jelly Bellies. You don't like this flavor, so you don't get that one, but you want this one, so you take that one. It's just, It's stupid. It's just,
I like that.
You just got to go and collect the ones you want, and do what you want with it. It's ridiculous.
Right. Right.
One part of it can stand alone. That's just
right.
That's insanity.
So that brings us to the scary stuff part. And obviously everything that we've talked about, in my opinion anyway, is very, very scary. But here's some more scary stuff that really, really bugs me. So, number one, the notion that California will not respond to civil suits from other states. So if you're a parent, one parent absconds with the kid to California, you sue, California is not going to respond to that civil suit if that civil suit pertains to gender-affirming actions.
Even if you're
even if you're the legal guardian or parent.
Guardian of the child.
No.
That's ridiculous.
And like I said before, I wonder how far does this go? What if Aunt Janie decides that Jimmy is Janie? Then what? She takes him to California to get gender-affirming surgeries. You're his parent.
I guess that child's getting gender-affirming surgeries because California is going to make sure that they stay there and see it through. And California said they will see it through. Basically, this whole thing's broken down to where, hey, we will make sure that it starts and that it is seen all the way through to the conclusion.
That's correct.
I mean, and if they got to take the child away from you, they got to make you pay child support to support this child, and that's what they're going to do. They're going to make sure that your child of 8, 9, 10 years old is following through with the decision that they try to make.
Right. So then basically they also say, as part of this, hey, look, if you break the law in your state by transporting a child over the state line or taking a child from its parent, blah, 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 whatever laws you might have broken to get to California, California is not going to allow any of those to be affected or once you reach California. That's it. Once you reach California, anything that you did, short of, I guess, killing someone, getting that child to California for gender-affirming surgeries is forgiven and forgotten by the state of California.
Wow. If any means possible, get them there, and then they're gonna keep them there. They're gonna. That's crazy. Again, I'm just dumbfounded by this whole law. Once you start breaking it down and dig into it, it's like, who thinks of this stuff? Who doesn't think of the ramifications of what is going on? Of the introducing the this child into sex trafficking and into these worlds where these dark worlds where we're trying to protect our children from.
Exactly.
Because of someone says that, well, they told me yesterday that they wanted to get this surgery done, so we brought them over to California.
Yeah, and I mean, it's just bonkers. The next piece of this is one of the scariest pieces of this whole bill, and it's what we refer to as acting as a parent. And so here's what the bill reads. It says the child and the child's parents, or the child, or at least one parent, or a person acting as a parent have a significant connection with the state of California other than mere physical presence. Now we're going to find out here in a minute why this particular line is actually BS. And we'll get into that here in a second. So now my question is, Grayson, what the hell does this mean? Does this mean that this could be anyone who the child says is their guardian at that moment? Could it be Uncle Joe, Aunt Sarah, or some guy that just found on the internet that has significant connection with the state of California, meaning they just live there? I mean, they live there for 6 months. They have significant connection to California, and suddenly they're the ones that are responsible for the gender affirmation surgeries that this child wants. What the hell?
That's what it's saying, and that's exactly what it's doing.
Yeah, or a person acting as a parent.
Freaking crazy, because somebody could sit in California and be like, well, and converse with somebody over in another state and go pick them up. And say, well, this is ridiculous.
It's just crazy.
I cannot believe that nobody thought to even pause when it comes to this. How does it pass?
I don't know. Now, here's another part that I also think is extremely scary. And this is what I was saying before about living there and just being physically there. Physical presence of or personal jurisdiction over a party or a child is not necessary or sufficient to make a child custody determination. So, in short, what this means is the state of California can proceed with hearings and decisions over custody without the parents or the child being present in the state of California. This means that a child could call the state of California, talk to the right person. California, like we said before, California will then reach into your backyard and boom, your rights are gone.
You're done.
That is just crazy.
You can't even protect your child from this insanity. That's
No.
what it seems like. You can try, but if your child's determined to do what they want to do, then when it comes to this gender affirmation, it's crazy.
Yep. Okay, so the next one here, we call it Just Get Yourself Here. And what the law says is this: the presence of a child in the state of California for the purpose of obtaining gender-affirming health care or gender-affirming mental health care as defined by Section 16010.2 of the Welfare and Institutions Code is sufficient to meet the requirements of paragraph 2 of subdivision A, which just said that they need to have meaningful association with the state of California. So to associate yourself, the mere presence of the child in the state of California for the purposes of obtaining gender-affirming health does meet the requirements of paragraph 2 of subdivision A. And that's why I said earlier that subdivision A piece was actually just fluff and was complete and total BS, because it's contradicted by this part of the law that says standing before somebody saying that I want to affirm my gender is enough to constitute the requirements. So, in my opinion, if this doesn't raise the hair on the back of your neck, again, I've said it several times, I don't know what the hell does. This article of the law states that someone has the right to show up and say that they're there for gender affirmation procedures in the state of California. And they instantly become a significant connection to the state of California and therefore protected by this law and can begin gender-affirming procedures without the consent of the parent, simply by standing there in the state of California.
Again, speechless. I can't even say anything else anymore. It's just, I'm speechless. This is just insanity. I mean, where's California gone? How far down the road have they gone?
I can't even imagine. So I'm going to bring a little conspiracy theory, a little humor to this thing, even though as incredulous as it is. And but I feel like, so I'm going to play the devil's advocate here, Grayson, for a second. So let's say that a physiological female who identifies as, you might need some algebra or geometry to keep up with this, okay? Mm-hmm. A physiological female that identifies as a male arrives in California to be reassigned as a girl. Would it be possible for this physiological female to get gender-appropriate implants based on their desire to get reassigned to a female? Mm-hmm. They're a physiological female who identifies as a male, so that now the male wants to have gender affirmation as a female.
So they want to switch back.
No, he doesn't want to switch back. She is a physiological female who identifies as a male who wants to be a girl.
Okay.
Right?
Okay.
Right? Yeah.
Now I understand.
Right. That's what I'm saying. You got to break out the algebra for this one.
Exactly. You got to think deep on that one.
Yeah, it's a thinking man's game on this one. So my question is, would it be possible for her to get gender appropriate breast implants, and at what age? Because there is no age limit on this law. And we all know that gender is fluid. I'm a boy today, I'm a girl tomorrow. Yeah, so I'm a physiological female who identifies as a male who wants to transition to a female.
They aren't already a female.
No, because in her mind, she's a male
Okay. Well,
who wants to transition to a female.
yeah.
Now what? So, at what age can the gender affirmation surgery take place? And obviously there is no age limit on this thing.
Yeah, because they
And if the child is a ward of the state, my question is, you've got all this gender affirmation surgeries and pills and mental health stuff going on. Who the hell's paying for all that? Are they going to come back to the parent
exactly
for that money? I mean,
why wouldn't they? They've done everything else. Why would they try?
I'm guessing that's what the state of California will attempt to do, is they'll come after you to pay the bill for surgery that you wouldn't have allowed to begin with, that the state of California said was required now because their child put their little pinky toe in the state of California.
Yeah.
And now you're on the hook for hundreds of thousands of dollars.
Somebody has to pay for it.
Someone's got to pay for it. Maybe the state of California would like to pay for it.
They can't. California can't even pay to keep their electric grids up.
No, they can't. But hey, you know what? Maybe they can afford to chop some penises off instead.
Yeah, this is all. This is one of the most mind-blowing laws I've ever researched or dove into and looked at. But this one takes the cake. California is.
Oh, I'll bet you that this isn't the scariest one out there. It just happens to be that this one we decided to deep dive.
Yeah.
So we're going to have a lot more of these, ladies and gentlemen. We're going to be deep diving into some of the craziness that's going on out there. That's kind of the purpose of this whole channel, is to deep dive into things, to bring you more information about things that are going on that maybe you didn't know about, or maybe you did and just didn't have all the information pieces that you wanted. That's what we're here to do on Talk IRL. Listen, guys, we really appreciate you watching the show. If you care to watch another one, like the show, share it, with your friends and family. Let them know about what's going on and how this law affects parents in all 50 states. It does not matter where you live. The California law is going to affect everyone. So share it with everybody that you can. Make sure to subscribe to the channel. And Grayson, I think you've got some tchotchkes out there for these guys if they become members. Is that right?
Oh yes, you're talking about the merch out there.
Yeah, absolutely.
The nice, beautiful cups we have in different colors with our logo on it, and the t-shirts.
The t-shirts. We got hoodies. We got other stuff coming. So if there's a tchotchke out there that you think would be fun, let us know. We're all about adding that kind of stuff, hats and things like that. So hey, listen, thanks again for watching us. We appreciate it. Everybody have a good night. Signing off, Grayson.
All right, have a good night, guys.